Okay, hi everyone. I hope I'm audible. Shall we start? Can I get a quick shout out that yes, you can hear me? Okay, yes. So, when we talk about CLAT again, and when we look from the perspective of Indian Contract Act or the basics of contract, CLAT has always focused on it. And if you go back and analyze last 4 5 years ka paper, you'll realize that they have been asking questions from contract and the very basic questions, basic passages like what is communication to contract, when a contract can be called as a void contract, voidable contract. So the very basic thing, what is offer, what is acceptance, all these are very important from CLAT perspective. And when we take into consideration the subject, so subject may contract, torts, criminal law, constitution, and certain aspects of family law, certain aspects of IPR, all these becomes very relevant. And why contract is important is this is something which we which happens in our day to day basis. In our normal transactions also we are entering into a contract. For example, if you are purchasing an ice cream, so there also you are entering into a contract. So this is something which regulates our day to day conduct, and that is why CLAD has always focused on contract. And even if you go back to question paper before 2018 2020 also, the older pattern principle and fact based questions, they have been asking questions from contract. And again, when you look into contract, it can be classified into different aspects. So till now whatever we have discussed in legal studies is we have discussed the syllabus, the type of question which CLAT is expecting from you, then the three type of passages which they have stated, that will be asking pure legal passages, public policy based passages, and moral philosophical aspect. This is what the syllabus state. Then in last 3 4 classes we discussed the basics terminology which we come across on regular basis. Then to clear the confusion as to what to read in IPC and what to read in BNS, we also discussed the difference between IPC and BNS and what is CLAT expecting from criminal law perspective, whether they focuses on sections or not. So that is something which we have done till now. Now we are going ahead with the specific subject. So today I'm starting ahead with contract. Once we are done with contract, we'll be moving ahead with constitution, because again constitution is something which is the, you can say, law of the country. Then once we are done with the constitution, we'll move to torts or maybe criminal law or vice versa, and then accordingly we'll be covering each and every subject. Maybe there would be classes where we would be discussing questions also based on legal passages. So passes will be visible on the screen. You read the passage, then you would be getting questions. After reading the passes, solve the questions. So you can also suggest that from next class onwards, like let's say we are done with contract, हमने contract कर लिया, so would you want to have a session on passage based questions and discussion? Then we can go ahead like that also. Contract done, एक सेट कॉन्ट्रैक्ट का सॉल्व करेंगे, फिर नेक्स्ट सब्जेक्ट पे जाएंगे, उसको खत्म करेंगे, तो मे बी पास्ट ईयर पेपर से वहां के कॉन्स्टिट्यूशन के क्वेश्चंस उठाएंगे, will solve it, then move ahead. So this will also give you an idea as to how to solve in mocks, how to go about the questions, where you have to apply prior knowledge, where you don't have to apply prior knowledge. So these few things will be taking into consideration. So agenda of today's session is we are talking, or we are discussing the very basics of contract. So the first thing is fundamental of contract. If we say, we have Indian Contract Act of 1872. Here, contract may be in writing format or oral format. There is no specific mandate by law that आपको written में ही contract करना है या आपको oral में ही करना है. If you go by written contract or if you go by oral contract, both are very much valid. But it is always advisable to go for a written contract rather than going for an oral contract. Why? Because sometimes it gets very difficult to prove before the court of law that there was an oral contract. For example, right now to we are in telephone, you can say we are through e mode, we are discussing something. Let's say a hypothetical situation में लेते हैं that I met somebody and I told him that I want to sell my car. So in that particular case, the person paid me the money and now I'm denying that I'll not sell you my car. And me and that person is only one who is, aware of this contract or this agreement. So in that particular case, if he has already given money, he is having no evidence, nothing, or there is no witness also. So sometimes it may get difficult for the person to prove before the court of law. So even if it's a written contract or oral contract, it's a very much valid contract. But it is always advisable to go for a written contract, so that in future if something wrong happens or if there's some sort of dispute, you have certain proof. So this is one idea of contract. Then contract can be an express contract, contract can be an implied contract, or contract can be a quasi contract. So when we say express contract क्या होता है? As the word itself suggests, you are expressing your desire. You are expressing that you want to sell your car. It can be in a written format, it can be in oral format, but where you are expressing your desire to enter into a contract, it is called as an express contract. Again, when we say express contract, written or oral, it can be in any format. So that is what is express contract. Then the next one is implied contract. Implied contract is where it is not expressed through written or oral format, but your conduct is like that, your gesture is like that, that there is a contract. For example, suppose a person is supplying good to another person, and that person keeps supplying goods to the other person, and the other person is neither saying no nor saying yes, that mujhe chahiye goods nahi chahiye. So there is a sort of implied contract, that yes, till the time person denies that I don't want the good, if he is accepting the good, so even if there is no express written or oral agreement sort of thing, his conduct is reflecting the same. Or for that matter, let's say there are 4 5 people standing over there in a group, and one of the persons says that I am agent of, let's say, Mr. X. Mr. X neither says yes nor says no, so the other 5 will assume that Mr. Y is an agent of Mr. X. So here also the conduct of Mr. X is creating a feeling in the mind of other people that Y is working as an agent. So implied contract also is of similar kind, that even though you haven't expressed it, but your conduct, your gesture is proving it. Quasi contract, if we say, it has different perspective, but अगर layman terminology में समझना है, and just for your basic understanding, it is, so law says that there cannot be an unjust enrichment. That means you cannot get benefit out of somebody's else contract. So let's assume a very simple example, which I always give, that let's say you have ordered a pizza, and instead of delivering it to you, the delivery boy gave it to your neighbor, and your neighbor consumed that entire pizza. So, in that case, the contract was between you and the pizza company. But since your neighbor consumed it, automatically your neighbor is becoming party, and that neighbor, because he or she has consumed your pizza, is bound to pay back to you, or maybe is bound to order a pizza for you. So, there, even though initially there was no contract, but because you have got benefit out of somebody's else contract, you become party to the contract. This is one aspect of quasi contract, which is also very similar to privity to contract, but from CLAT perspective, this is something which we need to understand. Then, when we talk about contract, again, I'm not asking you guys to go back and read the bare act of contract, because that is not needed. If you actually sometime feel like going and reading from the bare act, so आप कर सकते हो. बस उस केस में only those sections, those topics which we are discussing, you can go back and read it from there. Also, you can read the illustrations which is given over there, the example which is given in the law. Otherwise, it is not needed. And whatever basic is only what, from CLAT perspective, your basic understanding is something which will suffice. So when we talk about contract, contract is an agreement which is enforceable by law. An agreement which is enforceable by law is equal to contract. And when we see an agreement, so agreement is an offer plus acceptance. Also, it includes consideration. So, for example, if I'm saying I want to sell my car, somebody from your side said that yes, I want to purchase your car. So, the moment I said I want to sell my car, I'm making an offer to the other person, and the other person is accepting it. Yes, I'm ready to purchase your car for, let's say I had given an offer that I want to sell my car for 1 lakh. The other person said, "TK, I'm ready to purchase your car for 1 lakh." So there's an offer plus acceptance. And whatever offer I have given, the other person is accepting it in the same sense, same manner. उसने कोई counter offer नहीं किया. So there it is known as offer plus acceptance. And when we talk about the term consideration, for me, it would be money. For you, it will be the car. And here, when we talk about money and car, both of them are legal. It is not something which is, prohibited by law. This is not something which is barred by law. So there it becomes legal enforceable factor is also coming into picture. What will be not legally enforceable would be anything which law does not recognize. For example, there is a contract to do an agreement, sorry, not contract, an agreement to do an illegal thing. Illegal thing, let's say some offense which is prohibited under Bharatiya Nyaya Sanhita or IPC. So there is a such sort of agreement. So in that case, let's say किसी ने किसी का, I mean, the agreement is about some offense. Somebody did that offense. Now he is asking for the money. सामने वाला is not giving the money. So he cannot go to the court and say कि मैंने इसके कहने पे I did a crime. Now he is not paying me back. Because law says when you are coming to me, you shall come clean hand. If your own hand is dirty, how can you claim certain, benefit from the court? So only those things which is recognized by law, which is having some recognition, which is valid under the eyes of law, will be considered as a legally enforceable factor will come into picture. So an agreement is offer plus acceptance. When two or more people agree on the same thing in the same sense, they are said to be in agreement. When one person does not or refuses to do what was agreed, other person can go to the court and force him to do so. That is what is legally enforceable factor. That if one party has done his part of job, if other party is not doing it or other party is breaching the idea of contract, so you have all the right to drag that person to court of law for the enforcement of contract. So I hope what is contract, what is express, implied, quasi contract, what is offer, acceptance plus legally enforceable factor is clear to everyone. So always remember this definition that an agreement which is enforceable by law is called as a contract. When we talk about agreement, agreement is a very wide term. Very wide term means it can be for illegal thing also, but law will only recognize those which is legal. So agreement is a bigger term, contract is a subset of agreement. I don't know why the slide is looking like this. It got some, I mean, something is there any which way. So just focus on what I'm saying. So agreement can be for illegal thing also, but since legal enforceable factor is missing in that particular case, it cannot be called as a contract. So we can say agreement is a set, contract is a subset of agreement. Then when we talk about contract, contract focuses on intention of the party. And here intention of party would be you want to enter into a legal relationship. You want to, go to the court, maybe you can say in case somebody breaches your contract, in case if there is a friendly arrangement, or if there is a promise between or a offer from father to son. So in that particular case, if one of the party does not fulfill it, you cannot drag your father to court saying कि आपने offer किया था, you'll give me the latest iPhone if I get NLS Bangalore. And once you got NLS Bangalore, your father refused to give it, you can't drag him to court saying that there was a contract, because here intention of party is missing. Legal intention is not there. It is out of love and affection. It is because your father wants you to get into NLS Bangalore, and that is why he is making a promise, thinking कि if I'll make a promise of giving a latest version of iPhone or Mac or whatever you want, so in that case the student will study. So that is the aim and agenda. यहाँ पे legal enforceable factor नहीं है. In case of contract, there's always a relationship which is based on legally binding obligation, or there's an intention to enter into a legal relationship. For example, if there's a contract between husband, agreement between husband and wife, where husband out of love and affection is saying that I'll be paying you certain amount of money, or I'll be sending you certain amount of money, you stay back in this particular city, let me go back to my workplace. Now he is at his workplace, wife is in some XYZ city. Some difference arose between them. Now wife is filing a suit against her husband that why you are not paying me the money, or why you haven't sent me the money. So in that particular case, it cannot be called as an agreement, because husband, assuming that he is the husband, has promised his wife that okay, where will you go to my workplace, you take care of your health, you stay back here, I'll be sending you the money. So in that case, the intention of party is not to enter into a legal relationship. But where, even if in case of parents, where the intention of party is to enter into a legal relationship, it can be called as a contract. For example, you need not to know the case name and all, but I'm just giving a small idea. So there's a case where daughter is earning really good amount of money, and now she is getting an offer from a university for her further studies. She does not want to go for that further studies because she is earning really well, so she is in this dilemma ki job chhod ke jaye ya nahi jaye. So her mother comes into picture. Her mother says, you please go and complete your study, I'll be taking care of your expenses. Now this course is for 3 years. Mother kept sending money for 3 years. After that she stopped paying her money, and the daughter, she couldn't complete her education for next 5 years. So mother after 3 years stopped paying her money. Now some differences arose because obviously she was earning, now for 2 years she's not having money, so she filed a case against her mother. In this particular case, court again took a different perspective. Court said even though it's a mother and daughter, here she was having a well established job. She left that job and she went for further studies basing on her mother's promise. So here mother is bound to pay for 3 years but not beyond that, because mother ने सोचा था कि 3 साल में बेटी will complete my daughter will complete the course, but she couldn't complete the course. So in that particular case, court said that there is a contract, but only for 3 years, not for 5 years. So everywhere intention of party is taken into consideration. And if intention reflects that yes, you are intending to enter into a legal relationship, that will come into picture. Then, what is offer and what is acceptance is another aspect. Offer, as I just said, if I want to sell my car, so I'm making an offer to you. And acceptance would be you are saying that yes, I'm ready to purchase your car. I'm saying I want to sell my car for 2 lakh. You are saying you want to purchase my car for 2 lakh. So there's an offer. Acceptance is also in the same sense, same manner, which is also known as that there's a legal maxim, which is consensus ad idem, which means meeting of mind, which means in the same sense, in the same manner. So there is an offer and acceptance. And if we use the term consideration, so consideration means something in return of something. So here car is, you are getting car, I am getting money. So this is what is consideration. Even if you go back to the normal day to day activity, barter system, barter system is also a kind of, you can say, contract, where one person is in need of XYZ product, the other person is in need of ABC product. So they are exchanging. XYZ ABC ko mil raha, or ABC is getting to the XYZ person. So in that particular case, there is an offer, there is an acceptance, and there is a consideration, and these three forms a very important aspect from the offer and acceptance perspective. Then offer and acceptance is also kind of, there are two types of offer, you can say. One is specific offer, the second one is general offer. When we say specific offer is if I am making the offer to X person that I want to sell my car. So here only X person is having the option of accepting it or rejecting it. So this is known as specific offer. So example here is saying when offer is made to a particular person and that person can only give the acceptance, it is called specific offer. For example, A makes an offer to B that he wants to sell his mobile for 2000. Over here, the offer is made specifically to B and therefore it is a specific offer. General offer, if the offer is made at public at large and whosoever accept the offer, it will fall within the definition of general offer. Again, there is a very famous case law. Again, you need not to remember the case name, but just for reference, it is Carlyle versus Carbolic Smoke Ball Company. So the company made an announcement saying that whosoever will consume my smoke ball will never caught influenza. This person, Carlyle, she consumed it, she got it. Now she is claiming the reward, and the company is saying ki I did not make an offer to you. Here court stated that a general offer because you made an offer to public at large. She accepted your offer, she consumed it, she contacted the disease, so now you are bound to pay it to her. So general offer is like if I'm making an announcement that I want to sell my car, and somebody comes and says, okay, I'm ready to purchase your car. So here, this is what is general offer, that if it is made to public at large and not to any specific person, it is called as a general offer. Example, there's an example given over here that America advertised in newspaper that if anyone finds Al Jawahari will get the reward of $10 million. Over here, it is a general offer by America, and it will become a contract when somebody finds Al Jawahari. So this is just a generic example which has been put over here to explain you that what is specific offer and what is general offer. Then what is the essential requirement of offer and acceptance? Communication is very important. Communication of offer is very important. Communication of acceptance is also very important. For example, I am thinking of selling my car. I'll sell my car today. So if I am thinking of selling my car, and I'm not telling this anybody that I want to sell my car, but I'm just thinking that I'll sell my car. So here there is no communication of offer. जब तक मैं लोगों को बताऊंगी नहीं, जब तक I'll not make this offer, how will I assume that somebody will come and accept my offer? So communication plays a very important role in contract. Communication has to be very clear. Communication cannot be vague communication. Communication should be that what which car you want to sell. Let's say I have two car, A and B. Now I am thinking of selling A car, you are assuming that she wants to sell B car. So again, this is not a proper communication. So communication, and similarly the acceptance is also very, I mean, there has to be communication of acceptance. For example, if somebody wants to purchase my car and he just thought that I'll purchase a car, but did not tell me, and if I sell it to somebody else, he can't come and say कि मैंने तो सोच लिया था कि I have accepted your offer. No, you have to communicate that to me. Unless and until you will not communicate, how will I get to know that you have accepted? And since I am not getting to know about it, they cannot be called as a contract. So example says A had a reward out for whosoever found out his son. B finds. So again, this is based on a very famous case law, Lalman Shukla versus Gauridat. Again, case name not important. I'm just telling you guys for reference purpose. So when we say Lalman Shukla versus Gauridat, what had happened that the nephew went missing. So uncle made an announcement. Uncle said, whosoever will find my nephew, I'll give him a reward of 501 rupees. Before this announcement was made, the servant of the house was already out looking for the nephew, and he found the nephew. When he came back, he got to know about the reward, that there's a reward of rupees 501, and he claimed that reward. Uncle said, nahi milega. So this person files a suit against the uncle claiming the reward. So here, court took into consideration communication of offer, and court stated that you had no idea about offer, you were already out looking for the nephew. How can you say that you had knowledge of the offer and then you accepted the offer? Since there was no knowledge offer, there was no acceptance from your side, it cannot be called as a contract. So in that case, the reward of 501 rupees was not given to the servant. So again, this is explaining that why it is very important to accept the offer, and why it is very important to communicate the offer, and why it is very important to know about the offer. Also, the second example says Jack wanted to marry Jane and accordingly proposed. In her heart, she accepted Jack as her husband, but was too shy to accept. Jack married Anna. Jane sues Jack for the breach of contract. If was there ever a contract? No, because communication aspect is missing over here. Then the next one is says, as I have already explained, that offer acceptance must be clear. It shall not be a vague offer. It shall not be a vague acceptance. A own three flat XYZ. B calls him, says he is willing to pay rupees 1 crore for his flat. Which flat is not mentioned. So there is no clear offer. Similarly, B calls A and says he is willing to pay rupees 1 crore for his flat X. A says, well, let's meet up and let's talk about the details. So here again, he is not agreeing to the fact that okay, I'll sell my flat X for rupees 1 crore. He is saying, ठीक है मिलके बात करते हैं. So there again, there is no acceptance as A statement is quite vague. So I hope this offer, acceptance, communication, everything is clear. Then invitation to offer and concept of postal rule. I'll take this in the next class. And before I explain these two in the next class, I would want you guys to come solving CLAT 2021 ka paper. In CLAT 2021 paper, they had asked a question on section 4 and concept of postal rule. So I am assuming that you guys will come prepared, and I'll take this and that particular question and passes also in consideration. So I'm keeping this for next class. If you have any question till now, whatever we have discussed, you may ask. Okay, so if there is no question, then I'll see you guys in the next class. But please come solving that, come prepared and do solve CLAT 2021 ka communication to contract wala passage. Okay, thank you guys. See you in the next class.